motion, Ms. Brutus?
Parker, okay.
Thank you.
Okay. Our applicants are well familiar with our quasi-judicial procedures, having gone through them more than probably everyone in the room. But I'll read them for the record. This is a quasi-judicial proceeding where the board acts in a quasi-judicial capacity. By law, it is this board's function at this hearing to make findings of fact based upon the evidence presented at this hearing and apply those findings of fact to previously established criteria contained in the code in order to make a legal decision regarding the application before it. The Planning and Zoning Board is not the final authority on such applications. It is advisory to the Board of Commissioners, and it is the board's job to make a recommendation to the Board of Commissioners on these applications. This board may only consider evidence that the law considers competent, substantial, and relevant to the issues arising from the application and the applicable code sections. If that evidence demonstrates that the applicant has met the criteria, the board is required by law to find in favor of the applicant. By the same token, if the evidence demonstrates that the applicant has failed to meet the criteria, the board is required by law to find against the applicant and recommend denial of the application. The parties to this hearing are the applicant and the city. The city is represented here by city staff. There is an established procedure which will be followed at the quasi-judicial hearing. First, all witnesses must give their testimony under oath. All persons testifying must give their name and address for the record. All testimony and questioning must address matters that are relevant and material to the issues under consideration. The city staff will present its testimony and evidence first. The applicant will have an opportunity to cross-examine the city staff and any city witnesses. The applicant will then present its witnesses and evidence. The city staff will have the opportunity to cross-examine the applicant's witnesses. Absent unusual circumstances to be determined by the board, a party's opening statement and presentation is limited to 10 minutes. At that point, we'll proceed to the public comment portion of the meeting. Members of the public opposing the application will be given the opportunity to present testimony. After all members of the public opposing the application have concluded, members of the public in support of the application may speak. Each member of the public is limited to 4 minutes of testimony. During the public comment portion of the meeting, members of the public present may donate their time to a speaker to extend that speaker's time. I won't go further with that since there don't seem to be any other members of the public. Following comment, the applicant city staff will have the opportunity to make a rebuttal evidence and make a closing argument or summary. The applicant will go first, followed by city staff. Absent unusual circumstances, a party's closing summary and rebuttal will be limited to 10 minutes. Following this, the board will consider the matter. I'll ask all those who intend to testify this evening to please stand and be sworn. Please raise your right hand. Do you swear or affirm that the testimony you'll give in this proceeding is the truth, the whole truth, and nothing but the truth? Are there any conflicts of interest on our first application tonight on the Bay Shore Drive, Bay Shore Heights site plan? Are there any ex parte communications on the application? Seeing none, our first item is Resolution 2015-42, amending application 14-62, site plan review for Bay Shore Heights, a 60-lot subdivision in the R100A zoning district located at, Loquat Drive and north to Bay Shore Drive. This was previously approved by the P&Z Board on October 20, 2014. Ms. Orwiller.
Thank you. As previously stated, this is an amendment to an existing site plan approval for Bay Shore Heights. Essentially, what occurred is the actual resolution had an error in it when the lots were actually identified, the number of lots. It was identified as 60 parcels, which it should have been. It was originally 25 parcels that was then subdivided into 60 lots. So that's what's being corrected today on the resolution for the substance of the number of lots. What additionally has been changed here is the Exhibit B, which was the site plan for the subdivision. The lots have changed size as a result of working with Swift Mud to get their Swift Mud permits. The ponds had to be enlarged and the configuration of the ponds changed slightly. As a result, the lots had to be changed to accommodate that new stormwater management system. All of the lots still meet the requirements, the minimum zoning requirements for the R100A district, so they are consistent with what was previously approved as part of the plan. However, they're not exactly the same. So since the resolution had to be amended anyway to add the 60 lots versus the 60 parcels, we decided we needed to amend the site plan as well and include a complete site plan as part of the resolution. So those are the changes that have occurred since this application was heard in October of 2014. I've included in your backup the Gopher Tortoise permit as well as the Swift Mud permit, so that you have proof and evidence that they actually have met the conditions that were the requirements of the resolution. However, those conditions remain in the resolution because they were part of that original resolution. Just because they've met those conditions doesn't mean we want to change those conditions. And with that, I can answer any questions that you may have.
When this first started, we started the hearings, the residents of Bay Shore asked that they would be advised, and it's in the minutes, or should be, if there was a tape or anything, that they would be advised by mail of anything such as the meeting tonight, and it didn't happen. So, the few that I saw a little while ago said they were unaware of this. They were interested in only being able to come and see what the difference in the change in the ponds would be. So I wanted in the minutes that we did not advise the residents on Bay Shore that this meeting was tonight and what it was about. And I would like to also ask that you put in the minutes the explanation that you just gave us.
We'll make sure that that makes it in the minutes.
Isn't it a requirement to notify the neighbors when something like this has happened?
Not on a site plan application. Site plan application does not require the same notice requirements we do for conditional uses, variances, and some of the other applications. We don't notice the neighbors for these particular applications. Had there been a request to be noticed, it was not part of my backup. Unfortunately, the previous staff here did not leave me a good record to work from. So being that there were several meetings that happened with this particular project, and it's a very convoluted history, many things changed over the course of 4 different applications, I wasn't aware that they had asked to be notified. So that's why notifications did not go out. Had I been asked, I would have requested from the city manager permission to do that.
Any other questions from the board?
Do y'all have questions for Heather?
I have a question. How many gopher turtles did y'all find there? We talked about that last time.
That's something the applicant can tell you how many they found there. I can tell you how many they're permitted to remove.
How many are they?
They are permitted to remove 6 gopher tortoises, up to 6 gopher tortoises.
That's all, on all that property is inundated with gophers.
We talked about that last
Yeah,
time,
it's
too.
inundated with gophers. And I've written the state about that. I'm surprised and I'm shocked that they gave the number of 6. I'm not trying to give anybody a hard time. That's wildlife, and you can come and sit in my backyard. On Saturday, we counted 12. Just on my property and my lots to the side, 12, and babies. So I'm shocked that the state said 6. And when the gentleman told me, I said, what happens? He says, we just dig them up and get them out with the dirt. That bothered me. But I do anything about it.
Do we know if there's someone has to go in and count these tortoises?
They did a study originally when they did this project, and their approval for this permit is actually based on that study that they did as part of this gopher tortoise permit. They had to adopt that study. The state adopted that as part of that information. Now, if tortoises have moved on since then, there has not been an updated study. This permit's good through January of 2016.
Well, they're gonna do it anyway, but I'm gonna tell you right now, and I hope it's in this, that there are more than 6. There's a lot of tortoises out there because you're next to the river. Sad.
You have any other questions for staff about the size of the lots or the ponds or anything along those lines?
I'd like to know what the configuration of the ponds are gonna be and how it's gonna affect over what was approved.
Excuse me, can you repeat that?
I'd like to know what the new configuration is of the ponds and how is it going to affect over what we approved? Because down the street from me, the gentleman that the drainage pipes could go under his property, there was supposed to be a pond there.
The ponds are shown on the site plan on how they're going to change. There's both an existing site plan and a new site plan there that show how the ponds have changed. The actual drainage for, that's not the site plan.
All I have is this inside and a photograph.
Yeah.
thought I may not have given you an existing site plan. How this is changing, and I can pass one around, I have the site plans, the existing site plan here. How this is changing is the pond configuration. It's been added, instead of being one larger pond, they've been split into three subsidiary ponds, so there's a large pond and then two smaller ponds.
That's on the photo right here.
Yeah, I
photo.
have that.
Yeah, you got that was a large pond, I think, and then,
Yeah,
This is not what she intended.
That's the new, that's the new pond. This is, just pass this down, it shows the configuration of the existing pond.
That's what we've got.
Okay, and
So
I'd
you all
like
do
to
that?
Yeah, we do
hear,
have it.
Heather, they've got this.
We've got this.
I'd like to hear if, how that's gonna affect
Yeah, that's this.
at the bottom of the hill, where that drainage pond is gonna be, where the drainage pipe, that gentleman's house, and as you go down the hill, how's that gonna affect the change?
The
on
drainage pipe has remained in the same place. All that's been changed is the
Yeah.
configuration of the ponds to accommodate the stormwater for the project.
Well, I'm not an engineer, so I have to take your word for it, but when we had the site plan and the people were here, that was a big, big contention of what was going to possibly happen, and the amount of water, what was it, a 3 or 4 year storm that pond was going to hold. So what are the statistics now?
Well, the pond's been approved by Swift Mud to meet their minimum requirements for that water basin, for the basin that it's in. I don't know the specifics of how many year storm it's going to maintain, but it's been permitted by the state at this point to meet the criteria that the state puts out there for stormwater management, and that exceeds our criteria in our land development code.
are you talking about the outflow out into the
Now,
river?
remember-
Is that what it
no,
was?
No, it wasn't the outflow to the river. What that pond was going to hold was a severe stormwater. That was the big discussion that night. Will it be sufficient? And we're told that design would be sufficient. Now it's gonna be changed, so I wanna know, with the change, what is it now?
The
Huh?
capacity has been increased.
The pond design tweaks were done to.
I think right now, I think we could hold off from the applicant comes to the podium. We could ask them questions also. So, as of right now, I think there's also a concern. I think it was Mr. Andropoulos that was here last.
Yes.
That had a concern with his property. And I don't know if we could wait to ask the applicant, or if you know if that's going to change at all at the end.
I couldn't
Going
get a
into
hold of
Bay
him to
Shore.
tell him this was on.
The outflow is not changing as a result of the pond relocation. What's happening is the staging of the ponds is gonna be different. Because of this design, it allows for more water to actually be managed on the site because it's a larger pond and the treatment's a little bit different than the treatment with the one larger pond.
I want to know when the applicant's up, where these ponds are. I'd like to know in configuration with my property, Mr. Andropoulos's, because we spoke at length about it.
Yeah, we could wait to ask those questions when they come up. Do we have any other questions for the staff right now? For the rest of the board? Okay, thank you.
Good evening. My name is Bruce Danielson, 36 Winston Drive, Bel Air, Florida. I am the applicant. In regards to the ponding structure, the ponds are located in the same place they were previously. They were not moved. The style of construction of them has changed a little bit, only based on Swift Mud requirements to add more capacity to what they can handle and what they can treat. So as far as where they're located in regards to your property, Ms. Protos, they haven't changed. They're in the same place as they were on the original site plan. And same thing with Mr. Andropoulos's. And the issue that Mr. Andropoulos had was actually how the water was going to be collected near his home. That hasn't changed. All of those issues are exactly the same as they were on the first application. The only thing that is different on this application, before we had one large pond, now it has been divided into 3 ponds of different depths so that it is capable of handling and treating more water than it was previously.
All right, the gentleman at the end of the hill there, where the drainage pipe is gonna go by his house or under his house or through his property, there was a pond supposedly to be in that area.
No, actually, the way it was originally designed, the one large pond would outfall into the current wetlands, which is where the pipe is located that takes the overflow out to the bayou. And none of that has changed either. The only issue that is different on this site plan in regards to the entire water collection and treatment and drainage system is the shape of the pond and the depths of the pond, but they are in the same location. The outfall is exactly the same as it was before, just as the collection process is exactly the same as it was before. It's truly just a change in the shape and depth of the ponds.
Well, when we had this discussion, as y'all know, I spoke at length about opening Eunice Drive. And y'all were going to help, but a previous commissioner killed it with the people there for the vote that night. And when we had the heavy rains, you couldn't even get down halfway from the hill from my house for the flooding. The gentleman with the house right there where they were trying to stop flooding into his pool area, his garage, and his home. If you were able to get through the water, which cars did stall because it was so deep, it didn't drain out, you got down to Sunset Drive and Riverside at the Asamac home, and you couldn't even get through down there. Cars were stalled. I don't know when this is going to be in front of the commission, but I'm going to go and press again to open Eunice Drive, because if there was an emergency, and I don't know if this board wants to make a request again, but if there was an emergency with the elderly people there, they couldn't have even gotten an ambulance through there to get them to the hospital. That's how bad it was.
To answer your question, this will be going to the board tomorrow night.
I'll be there, because that is a safety factor, and the city needs to open up Eunice Drive for the health, welfare, and preservation of the citizens and all those homes on Bay Shore with this development going through.
I have a question. What's the average elevation there?
Right now, the property ranges from about 2.5 feet up to 14 feet. And
I'm
we're,
the highest, I don't need flood insurance where my house is.
right. And when this is completed, all of the homes will be outside of the flood zone.
Okay.
Now, when those homes, like behind me, are completed and they're higher, I hope I don't have flooding on my property.
No, they're still going to be lower than where you're at you're like on the top of the mountain.
Yeah,
And-
I flood all of Tarpon floods.
Yeah, they are going to be at 10 foot, right where they need to be out of the flood zone. You're higher than that.
Any other questions right now from anybody else? I think just to clarify though, West Bayshore is going to connect and is able to get out to Riverside.
Correct.
Okay.
West Bayshore will be connected all the way through, and also part of our project is that we are raising up the section of Bayshore where Ms. Protos is talking of the severe flooding in front of that gentleman's home. That part of the roadway will be raised up, and in addition to that, the current pipe that is there is only 18 inches. The pipe that we are installing to drain the area is 48 inches. So the volume of what it can take out of the area is exponentially larger than what is currently happening.
But see, the tide was so high.
Well,
it
tide, we
took
can't,
over.
tide,
I know you can't control the tide, but that's what's gonna happen there.
Well, in 50 years, we're all underwater anyway.
But until then, I would like to see some of our properties preserved, and we don't have the problems we had with the big rains. Because I tell you, down the street from me, 7 cars were stalled in the water that tried to get through.
Yeah, they're all throughout town too. It wasn't.
Yeah,
It was
that's true.
multiple spots.
But my point is, emergency-wise, you couldn't get in and out of there.
Yeah, and I think that's you bring up a really valid point, Ms. Protus, and I think West Bayshore should be able to help with that a lot too.
Not unless
Um,
Eunice is connected to it, and it won't be.
And I'll go ahead and just express my concern with Eunice too. I've grown up in the area, and I think it's a good idea, but at the same time, I think there's also another safety concern if we continue to push it all the way through to, is it Bayshore? Yeah, Bayshore it comes down off a steep hill, and as we know, there's a lot of people that speed down these roads in Tarpon, and I think that'll also create a safety concern too. So I'm also expressing, I do see a benefit in bringing it through, but I think there's also another safety concern with the traffic with the blind corner. With if you have a more mature, maybe elderly person in the community driving, maybe taking a turn, and then having a younger individual, maybe a high schooler, coming around the corner faster than hopefully we would expect, but I think there's still a concern there too, so it's something to also
On
weigh.
Eunice, and I understand, respect what you're saying, but on Eunice, you have a clearer range of view than if you had come out on Lucille. And Eunice used to be open with shell many, many years ago, and the residents were able to get through on that shell road.
Yeah. Do we have any questions right now for applicant, or we can move to a vote? Or public opinion, or discussion?
Heather, you want to ask Mr. Danielson anything?
No, you're not.
Mr. Danielson, do you agree with the staff's recommendation for approval of the site plan?
Yes.
Much appreciated.
When are you gonna start?
If everything goes according to plan, the silt fence will start to be installed in December.
You know what I'm concerned about, the rattlesnakes. But I am very disappointed with the gopher turtles. I think that is just deplorable.
I'm sure that there's a volunteer organization that can go in and
I
help
don't know.
remove them.
Well, that's up to the developer if he wants them on his property. He
Uh,
can move them all.
There's a process for properly capturing and relocating, which is what we have, which is what our permit is for, and which is what will be done. So we've done everything to the full extent of the permit, and it is approved and just waiting for us to start.
Unless the governor allows hunting in public lands and bear killing.
I also didn't see any public comment, so we could move forward with a motion if there is one on the board.
I have a question.
Okay.
What are we actually agreeing to?
The way staff brought it was we are,
It's just a site plan approval. You've got a development agreement already in place with these folks.
All we're doing is
So
amending
that's
it,
been
You're just,
approved already.
yeah, you're simply amending the site
That
plan.
word.
The-
those words.
That's my question. Okay.
any other clarification?
I'll make a motion that we approve resolution 2015-42, amending the resolution 2014-32 for application 14-62, site plan approval of Bayshore Heights.
A second.
Who was the second?
Mr. Parker?
Thank you.
And they are within their rights with the law.
Yeah. Mrs. Protos,
Yes.
Mr. Nass, Mr. Nass,
I think it's
Yes.
talking about
no, I'm
Haas.
sorry, Nace,
Who?
Haas.
Hasi?
Haas,
Haza?
oh, Haas,
Either one of those will do, or Conejos.
okay,
He's trying to say
Yes.
the first name.
okay. Miss St. Arnold,
Yes.
Mr. Parker,
Yes.
Mr. Carr,
Yes. Hey, can I ask one more just clarification question? I'm just curious, out of curiosity. If they don't start construction now and pull the turtles out of there, their permit goes until January 1st of 16, so they're going to have to reapply for it, right?
That's correct.
So that-
And if the state at that time requires an updated survey for the tortoises, they would have to do that.
We're going to move on to the next application, number 5.
Application number 15-77, ordinance 2015-18, amending Article 7, Heritage Preservation, Section 110 demolition. A proposed land development code amendment to the text of Article 7, Heritage Preservation, Section 110, demolition, providing for a mandatory waiting period for demolition of a historic structure.
Thank you.
This is, for the record, this is legislative in nature. You're making a recommendation as to whether the city commission should adopt this ordinance. This is not quasi-judicial, be no evidence taken.
Thank you. This application actually came out of the Heritage Preservation Board. They requested that the city attorney's office prepare this ordinance requiring the mandatory waiting period for structures that had been demolished. How the process currently works is somebody would submit an application for a demolition. The HPB board would decide whether or not it has merit for demolition, and they use a variety of factors. They use real estate information. They use basically an architectural report or an engineering report on the condition of the structure to determine whether or not demolition is warranted. Obviously, demolition of structures in the historic district is something that's very contentious and very difficult to administer, simply because the more demolitions you have, the more integrity you lose for that historical nature of that district. So it's something that the Heritage Preservation Board feels very strongly about, that there be some control mechanism for having like a waiting period or a cooling off period. So they'll make their decision. They still have to bring an application. They still have to go through the process. Once they've deemed demolition as the option, they then would require the applicant to wait 6 months, and during that 6-month time, they would work with the applicant to try to pursue another alternative prior to demolition, whether that be a new owner of the property, where a new owner might be willing to come in and renovate the structure, or a private group who's willing to come in and take possession of that property, whether it's a non-for-profit or a private party, or if they could get the government to then purchase that property for preservation. Right now, there's not currently a process here in Tarpon for us to purchase properties. We just don't have the funds to do that for preservation reasons. However, from time to time, you have structures that are significant in origin, and people rally around those structures and they want to maintain them. So basically, the HPB board is asking this board and the Board of Commissioners to basically review an ordinance for this mandatory waiting period, which would allow for that cooling off period, to allow for additional time for the applicant to actually seek out another alternative for the property. There always is the opportunity as well to move a structure, a historic structure, from one part of the historic district to another one if there's open and vacant lots. And we do have some vacant lots mixed in amongst the historic district that you can move one property for that. We actually had an example of that over here on Ring Avenue. They moved the house across the street. So it is a doable thing depending upon the condition of the structure. However, if you're deeming a structure ready for demolition, the likelihood that it's going to be able to be moved is probably integrity is shot at that point. It's not going to be easily moved. So with that, staff reviewed this. We took it to the TRC committee. The TRC committee basically has some real concerns. They're outlined here in the staff report. There's not provisions in here for, fire, police, and safety and life safety issues. There's no provisions for removing unsafe structures that the building code official has that right to do. If the structure is deemed unsafe or a hazard to the community, they have right to go in and do that. There's no provision in here that allows them to do that. The proposed 180-day waiting period will discourage any development. It might discourage some development in the historic preservation district. And again, the proposed 100-day waiting period adds to a typical permit scenario, will realistically be 240 days or 8 months before the construction commences on any project. So if you have a mandatory 6-month waiting period based on the way what it takes for us to actually get a permit issued here in the city, you're basically adding additional months to that permit process, which is already fairly lengthy. For tracking purposes, and this is something that wasn't really talked about at HPB because as staff I hadn't had time to really look over this stuff when this came up at HPB. Tracking of these types of waiting periods can be very difficult. We don't have currently a permit system that does that type of tracking for us where it would be an automated system, so we would have to incur some expenses to create that system. Our permit system is capable of it, but we need to have somebody program it or help us program those waiting periods in. So there's a fiscal impact here that hasn't really been discussed at this point. And then ultimately, TRC staff felt that it's going to be perceived negatively by contractors and of our citizens having this mandatory extra waiting period that people have to have. When I went through and looked at a whole host of different ordinances, there's 14 here listed in a chart that I did for you where there is mandatory periods or not mandatory periods. Some people do have mandatory periods, some people have more stringent mandatory periods than what's being required here. But a lot of the ordinances leave that up to the discretion of the board. So if the board chooses, while they're reviewing a demolition application, when they do their certificate of approval, which is what they get at the end of the process, if they choose to add to that a mandatory waiting period of whatever number, it could be 90 days, it could be, more than 90 days, it could be 6 months. If they choose to do that, it's at their discretion. That board is like our citizen experts on our historic preservation board. It makes more sense to give them the authority to be able to make that decision at the time when if it's deemed necessary, whether or not they know that they can get somebody to come in and work with them to remove this home and move it to another location, or if they know that there's a buyer out there that's willing to pick up the property and renovate it. So staff, I really have some concerns that this mandatory waiting period may not be the best way to go. I have concerns about not looking at the costs associated with updating the permit system before this comes before you, because that's a cost that the city will bear if we adopt this right now. And it's not a cost that we have currently looked into. It's not something that we've budgeted for. So it's a concern that we haven't looked at that and gone that way. So with that, and with what basically the technical review team is telling you, which is our building official, our public works director, our engineering folks, the economic development director, myself and my staff are on that board. There's a majority of experts here that the city has hired that are telling you that this may not be the best alternative for us. Now, it doesn't mean that it's not a warranted action. HBB has a mission to preserve the historical resources of this community. That is their intention, and what they're trying to do here is do that. I just think that there's a better way to at least go back and look at this and look at some of the alternatives, because I wasn't part of that conversation. That conversation happened before I arrived here in Tarpon. I want to have the opportunity to have those conversations with those folks, look at some of the provisions in a board setting so that they can understand the alternatives that are out there. Unlike this board where you guys see LDC language all the time, you understand the impact of these codes and what they mean and how they affect development. HBB doesn't have that same understanding. So because of that, what I'm asking for at this particular time is to have this ordinance tabled so that we can have some time to work with HBB to look at what the cost to the city is actually going to be and go to the city manager with that recommendation for this to be implemented. And maybe rather than providing for a mandatory waiting period, we provide the board discretion to have a waiting period if they want. I mean, they've already done this in certain cases. The Ring Avenue project was a great example of that. They had a home that was up for a long time. It's just recently been demolished, that there was a sign on, free house, because they were really trying to find another place for that house to go in the historic district. They just didn't have the means to do that. And the development that's going to go there is obviously going to be a really nice economic development boost and housing downtown, which is a new concept really for us. We haven't had new housing downtown in a long time. And that's another good project. So we would like to see that project go forward. But at the same time, we recognize it's in the historic district. It needs to fit the character of the historic district. And those demolitions do have an impact in that integrity of the district. So, and I understand where HPB's concerns are. I just would like to have the time to work with them to come up with an alternative if there is an alternative. I'll support a mandatory waiting period if it's the best choice, but I want to have the opportunity to talk to them about the options. So that's what I'm basically coming to the board with tonight for this application. If you want to talk about the specific languages, we can get into the specific language of the actual ordinance changes that are going to be done, but That's basically what I have for you, unless you have any questions.
I do.
Go ahead.
I live in a historic district, and I'm a huge proponent for historic preservation. So I happen to have a house built in 1926, and I am on 3 lots.
Mhm.
So what this is trying to do is say that if I wanted to tear down my house and build a mega mansion, it kind of gives the city and everyone else a chance to take a breath and say, can he do this or can't he do that? Is that kind of what this is?
That's correct. You would submit your application for that demolition. They would decide what ultimately they think is the best thing for that thing. And if they decided for the demolition, you would then, right now, if this was adopted, have to wait 6 months. And during that 6 months, you would work with the board to try to find an alternative. Obviously, there's not going to be alternatives all the time, but
And currently, you're saying that if I wanted to do that, it could maybe pass tomorrow that I wanted to do this?
if you had the justification and the HPB board supported your justification based on the condition of the house and other factors that they look at, then, and they approve the demolition, yeah, you could come in and get the demolition permit as long as you've satisfied any conditions that they put on your certificate of appropriateness.
And what you're asking us is that you don't quite understand, you haven't had enough time to really understand why they want 180 days. It could be maybe after you look into this, maybe you only need 30 or 45 or 90 days or something, is what you're saying. Are you as staff recommending that there should or should not be a mandatory waiting period?
At this point, I really want to really talk to them about how we do a waiting period. I don't necessarily think that a mandatory waiting period right off the gate, just that we adopt into ordinance, is the best course of action here. I think you have a very engaged historic preservation board that does a really good job reviewing applications. I sit with them every meeting since I've been here, and they really take a lot of care and interest in what's going on in the historic district. So I think that they are intelligent people who have the right passion for what they're doing, and I think that they should have the option to have a mandatory waiting period if they think that that's what's appropriate, but I don't necessarily, as staff, agree that a mandatory waiting period is the best course of action here. I think that that's going to turn people off, and we want to redevelop portions of the historic district because our CRA district, which is our redevelopment district, is within the historic district. So you're going to have people who want to do redevelopment projects here. It's going to eventually be that some of these buildings are going to reach their useful life end, and at that point, I want the board to be able to have the opportunity to obviously make that decision on a case-by-case basis rather than just having this mandatory waiting period. I think the mandatory waiting period sends a message that's the opposite message that our economic development coordinator or manager is trying to send. So I think that we need to balance mandatory waiting periods and how we do waiting periods for demolition along with some of the other goals that we're trying to do as a city and really look at those impacts.
So this then gives more power to the Historic Preservation Board.
Certainly, rather than it be statutorily or written in the code that how to do it, they would determine whether or not it's warranted. And there is a provision in here that gives them the option at their discretion to not do a mandatory waiting period. So they can decide to not do that as it's written right now. I think the language is here is really it's really a semantics thing, but it's more of the projection of the image that the city wants to project out there.
Can't the Historic Preservation Board delay this now, currently? Can't they have quite a bit to say so? They could say, we need this or we need that, we need more information on your property. I mean,
Certainly.
They have the power currently to delay these types of things.
Certainly they do as part of their certificate of approval of appropriateness. They have a lot of authority when it comes to what conditions are placed on an application and a delay or that type of thing.
So they have quite a bit of power already.
Correct.
Okay.
This would be just putting into the statute, or in this case, into the code, that
180
mandatory, it will just be that way.
Okay, thank you.
What about the property right, the rights of the property owner? If we do this, we're stepping on someone's rights to own the property, and they may have reasons why for their plans. So where does the property owner stand other than making them do this?
Well, essentially, if this is adopted today, there's a provision in the HPB section that allows for them to appeal an HPB decision. So if there was a demolition and this was on the books, they could appeal that decision if the mandatory waiting period had been imposed as part of their property. And unless the HPB specifically stated the way that this is written, that there's not a 6-month waiting period, it would be automatic that 6-month waiting period would happen every time a demolition certificate is approved, right? So at that particular time, you are getting into a question of, the property owner balancing that property thing, but the board, they have the right to appeal that decision, that certificate of appropriateness, to the Board of Commissioners. And we do have appeals from time to time. We do get them
The
at time to time.
scenario might be a historic building just crumbles from termite and falls down. They're gonna have to wait 6 months before they can move on, correct?
Exactly,
Okay,
that's
so-
a question.
See, we didn't use it uptown though on that building on Tarpon Avenue.
Yeah, I know. But I still
And we
feel
lost
that
that.
the Historic Preservation Board still has quite a bit of power to delay
They do.
these things. I have to agree with her that we wait and see what she has to come up with.
The analysis, I was very surprised to see that St. Augustine doesn't have it. And some of these do and some don't. This was very interesting here. I'm on the city historical board, and I do support preservation, but I also support the right of the property owner and the expense that you can put them through. And that's another factor. And we've already lost some homes, but they could not have been saved. And an example of that is what happened on the bayou, rest there. And Tarpon certainly has their share of older homes. I just have a problem with some of this stepping on the rights of the property owner. And the property owner comes first. The house that the city had him move across the street has been put on a piece of property that's had a sinkhole 2 times.
I agree.
And I was shocked to see that. The other building had been changed so much that it lost its historic value. That house, because I grew up in that neighborhood, had been changed at least 4 or 5 times. And that was my problem with doing that. The main thing in writing this is you own the property. You have the plans, you have the money, so much money that you can use. And I think sometimes we can write something so hard that we put the property owner in at risk because they can lose. To find someone to buy that property from them or work with something else, I think that's stepping on their rights.
Anita, I agree somewhat, but they still bought into a historic district and a historic home. They knew
Yes.
what they were getting into when they bought this property.
Maybe not. That's the problem.
That's true, too.
Maybe
Yeah,
not.
Everybody knows what they're buying into.
Yeah.
And you don't always
they
have people who
inherited
are buying into these properties. Some people inherit these properties
Exactly.
from family. You do still have people who are living in the historic district who have inherited homes from other family members. And, there's been limited maintenance over the course of, 4 generations in a house. That deferred maintenance eventually has an impact. And just to get back to the St. Augustine comment that you had, it was interesting when I looked at that, but it's totally at the discretion of that board. Rather than just requiring it outright, they have a program essentially that they work with the applicant to, try to find a different solution, but they determine at that meeting what that deadline is going to be. If it's going to be a 6-month, an 8-month, a 10-month, they determine that. That board determines that, and I think since they are responsible for these types of decisions, it makes sense to leave that determination up to that board. And it really is semantics when you read this. It's just the image that we want to project, that code that we have projects an image to the community whether we realize it or not. And Anita, you're hitting a lot on those issues of property rights and how do we protect a property right while at the same time we protect the residents and the city's interests at the same time.
You said it takes 6 months to get a permit in the city?
No, she's,
I did not say that. That came from TRC. Essentially,
Oh, TRC.
yeah, that
okay.
came from the building official on the first page here. The building official is basically saying that if you have the 6-month waiting period, the 180 days,
Oh, okay.
and you add what normally takes to get permitted, you're adding another 2 months roughly to get through the permit process to call for your first inspection. I'm sure that this is based on call for your first inspection, because you can get a building permit, and then if you don't act on it, you can let it go for 6 months
Okay.
before you call the first inspection.
And then I had on page 2 here, during the 180-day waiting period, the owner shall negotiate with the city and with any other interested parties in an effort to find a means of preserving the property. That means getting someone else to buy the property from you, and if you don't want to sell, you're still going to be handicapped.
Exactly.
I think this needs a lot of work and a lot of thought, because we're in America. You have a right to own a property. You have a right to appoint, it's your property, you're paying the taxes, and you've paid for it. And I know over 13 years that has been on the board, that has been my stand, to protect the citizen and the property owner.
Any other questions? Ms. Parker?
No.
Ms. St. Arnold?
Nope.
I've got a couple questions for you. Just
Okay.
get clarification. Well, I guess when I was looking through it, let me know if I missed it. It didn't talk about contributing structures versus non-contributing structures. So we have a historic preservation board that has guidelines based on both. Does this count for both of them? So a house that was
Yes,
built in 2000?
Demolition for non-contributing structure is controlled by the HPB board. So the HPB board in this thing, whether it's contributing or non-contributing, the way that this is written, there is no caveat if you have a non-contributing structure that, had been previously built, something happens, catastrophe happens, and we need to demo that. There's no life and safety provisions, there's no provisions for that type of thing. They would have to go through the same process.
Okay, that's a concern for one. I would say also that I see where the board's coming from, because the board's obviously term limit on boards, and maybe in the future boards there might not be as passionate as our current board is, and so a demolition permit could go through more easier, and so I understand what they're going towards, but I think what you're talking about is that's a pretty big one. The contributing versus non-contributing is a pretty big one to address. Another question, so if a hurricane comes through and knocks off half the house, because most of these houses are either sitting on stumps when they're built or 120-year-old bricks, it's very possible for that to happen. So let's say it's structurally sound. It also, let's say now it's structurally not sound. They would have to sit through the waiting period for that too, right?
Exactly, the way that this is written, because there is no section specifically in there. There's a section in an earlier section in the HPB language that would address for when there's an issue where there's a health and safety thing, but we really should do a better job outlining that here in this language, so that people are on notice when they're coming through this process of what their responsibilities are.
And can you clarify again, when does the starting period start then for this situation, if they were to actually move, like if we
It
were to
would
move forward
start
with this?
after the certificate of appropriateness or the certificate of approval is issued. So the night that they make their decision on the demolition, okay, that waiting period would automatically start from that night on out to 6 months, okay? However, sometimes there's conditions and things placed on those, so you would still need to meet whatever conditions they put on that before you could actually acquire the demolition permit too. So now, the idea is that during that 6-month period, if there were conditions placed on your approval, that you could work to, meet those conditions, whatever they are, during that 6-month period as well.
Well, if you want to demolish a building today, you would have to have some type of engineering proof to show that your building is structurally sound.
Yeah, it's
You'd have to have a
engineering.
cost analysis. You would have to have many artifacts that take longer than a month to put together to begin with. So there's a pretty good waiting period already.
I do
think the
not
board-
disagree with that statement. It's a lot of data.
And then I've got a question. Is there a current building coming ahead in the next that you've seen that's coming up for application for demo? That's in the process.
Not,
in the
there
historic
is one demolition that I know of that's going through, and that's 120 Reed Street, which is a single-family residential home. I don't know of any other demolitions that are in the works right now or on our agenda. our next agenda is mostly replacement of windows and doors and that type of thing, but there
That
is.
house is not considered a historic house, I don't think.
It's, I think it is, I want to say contributing but
But
altered,
altered.
but it's been a while since I've
It's
looked
been
at it. It's
altered
been a
and
good
it's
2
full
months
of
since
termites.
that originally started the process.
Kids don't have it. Do you have the backup on this analysis for Mount Dora and Tampa? I'd like to read what they
Yeah,
have.
I saved all of these, so if you have
Yeah.
any interest in any of these, I can print you off copies and have them come down to Rotary.
I'd
if-
like to read what they say. It would be
Do you
very
want,
interesting.
do you
I'm
want the whole
shocked-
list?
Yeah, I'm shocked that Tampa, with all their beautiful homes.
Tampa's got a kind of an interesting process, though. They have several boards you go through, so there's a lot of, they cover a
County,
lot of
yeah.
information.
And county, but St. Augustine. But I'd like to read and see
Sure.
what they do. Like I said, I just don't want to
What I did was I just took sections, the sections that would pertain to this, so you won't have the whole ordinance, but if you want more information once you get into it,
I'll try to come up during the holidays.
okay, you can come see me,
and
sure.
see if I get time off.
Okay,
Okay, we can
either
talk
that,
about
or
this
I
afterwards,
can
if you guys
print
want
you,
to.
I can print you copies and if you just let me know you want additional information, I can pull those sections. I have all the section headers, I saved all that stuff, so I wanted to have it.
So if anybody else in the public would like to come see that information, you know where to find the planning department.
In the planning
They
department.
do not serve coffee and cookies.
We do have coffee, we don't have cookies right now, but we could for the
Yeah,
holidays.
candy. All right, I move that this be tabled for further information and study.
Second.
Mr. Attorney, do we need to defer this, or what's the actual term?
Well, I want to discuss that with Heather, actually, while we have Heather.
And I want you to explain to us the property rights of the property owner.
Well, I don't know that explaining property rights in whole is necessarily what we need to do. As a procedural matter, Heather, the HPB has the authority to recommend to the Board of Commissioners changes to the Land Development Code. Tabling it is fine, but my impression is that that action would also need to be repeated by the Board of Commissioners before.
You need to hear it and deny it?
Well, their direction to staff in our office was they want to recommend a change to the code, correct? There's no mechanism in our code by which that can be stopped at the planning and zoning board level.
Well, we can go on to board.
Yeah, and I'm not suggesting that would be a productive use of their time, but in light of the fact that there's no mechanism by which we can table it now unless they withdraw it themselves, then it probably needs to go to Board of Commissioners.
Okay.
Are we hurting ourselves by not tabling it and sending them something that isn't thorough and thought through thoroughly? I mean, could that
Well, I
be a
mean, tabling
mistake?
it suggests to me that you're going to take up this very same application again,
Again,
this very same
again.
ordinance again. I think that probably, if I'm hearing you correctly, what you want to do is recommend denial to the Board of Commissioners, so when it goes to them in its present form, your recommendation will be denial based on the reasons that you've expressed tonight.
So you want us to change the motion
I-
to denial?
I think that's,
I
I
will
think
do
that's,
that. I
okay.
move that we have it denied, whatever you want to word it.
Second.
Do we want to, would you like to elaborate on why?
Why? I don't
Based on our
think that we have
discussions?
gone through it thoroughly. I don't feel that we have enough information on property rights and the legal ramifications of this. I just feel that it will handicap some people. We're all for historic preservation, but we have to look at this more thoroughly and make it more fair all the way around.
Ready for roll call?
How,
I'll
Are you
probably
ready
think
for
of a
roll
lot
call?
more things tonight as I think about it. Do y'all have anything to add to it?
are we able to add with other board members?
Clarification.
You've got a motion and a second, you can
Okay.
discuss it.
Okay.
When you're
Alright.
ready for the clerk to take a call, have her take a call.
It's just, I see what some of these other communities, I want to read the background from some of these other communities, how they base their no on it. For protection of the city, protection of the property owner, and the historic issue of the situation.
Any other discussion?
Roll call.
Roll call?
Can you help us?
we just need to take
with
a roll
other than
call.
what you told us, you know.
I think we just need to take a vote.
Yeah, we'll move
Do you
forward with
want
the roll
my
call.
opinion
and-
on your findings of fact for this one? I mean,
Well, listen, you're talking about a legislative recommendation here.
Yeah.
We needn't get too far into the weeds in
Well,
terms
she
of
gave
how we-
good recommendations.
Yeah,
So
and, you know,
those should be in it with us. Your recommendations, or your statements should also go along.
well, the
with
staff
it.
report will be in there, and and this is actually gonna have to wait a whole month anyway, because it's not gonna make it to board in 2 weeks. I've already got the 2 weeks agenda done for the next thing, so it's gonna probably wait a whole month before it goes to board. At that point, we can actually include the draft minutes, so all of the comments that we've talked about today, the draft minutes can be there so that they have that information and substance. And I'll probably include also the background that you're asking for, because normally I would have done that for an approval. If I was gonna recommend approval, I would give you that stuff, or I was gonna recommend denial, but I'd actually like to work with the HPV board, and just outright recommending denial is not the best way to make friends to actually work on this language. I want to
Yeah.
work with them.
You can blame that
So-
on the city attorney's office.
That's
when that
exactly
goes
what
back.
I'm
Please
planning
do-
on
Please
doing.
feel free to do that. You know, just let them know that neither the HPB ordinance section nor the P and Z ordinance section provides for that to be, you know, sort of essentially workshopped here and then sent back. You know, unfortunately, they have that power to recommend, and therefore, the Board of Commissioners, in my opinion, needs to pass on it, so you can.
And I think that's okay. We can
I just want it
procedurally.
fair all the way around.
I agree.
I said at that meeting, I was sat in the back of the room of that meeting when the gentleman came up, and I was never so shocked in my life.
It can be a really tough board to be sitting in.
And some of the statements I don't agree with.
But I'd like to put your minutes and basically the comments for this discussion as part of that backup, so that the board is aware of the reason why you're going forward, so that when I take this back to HPB, I can, you know, put everything on the table for them and say, okay, this is the recommendations they have, can we discuss it?
I want it right so they don't have to send it back to us after it's adopted. We have a problem.
I think we all have a passion, or I don't want to speak as a board as a whole, but Mr. Hossie has a property, Anita's grown up in here, I grew up in a historic preservation area. I was on the board also, so I've also have a passion for the historic district. It's
I live
not
in
to,
the historic.
not to show that we don't have a passion for it, but I think clarification and a little more information on the city staff would help too, so.
I agree.
Clarification, thought, and like you said,
I do agree.
this is a biggie and it's gonna affect a lot of people.
I'm going to move forward with roll call.
Mrs. Protos?
Yes,
Mr. Haas?
Yes.
Ms. St. Arnold?
Yes.
Mr. Parker?
Yes.
Mr. Carr?
Just a yes is agreeing to the denial, right?
Motion was to
Okay,
deny.
yes.
happy Thanksgiving.
We have staff comments.
Yeah, I just have one comment. I'm actually gonna probably send around to you, because I forgot to print off the schedule for next year. I have actually got it done, I just didn't get it printed off. So I'll send that around to everybody, so you'll have the meeting schedule for next year. It's also available on the website. Nita, I'll make sure a copy gets over to you as well.
Can you email that to us?
Listen, my daughter got out of France the other night. She hit Washington, Saturday morning at 5 a.m.
Good
off the
for her.
plane. She says, I'm coming home. You're gonna get a car, you're gonna get a computer. I'm sick of it.
Yeah.
But I won't have the computer, I'm gonna tell you right now. But, have you decided to stay with us?
For now.
Okay.
Now, the other comment that I have is I want to introduce you to our new staff secretary. She'll also be secretary to this board and all our board. This is Kim Yothers. And so I wanted you guys to get a chance to meet her and get to know her. She's kind of been thrown into the deep end for doing meetings, but she's been doing an awesome job. So I have nothing but the greatest expectations that she'll do great for you on doing your minutes and that type of stuff. So if you have other questions and you can't get a hold of me, you can always get a hold of Kim.
It's your phone system. That's all.
Yeah, I'm gonna try to talk to the IT folks and see if we can get the pod phone, because right now what's happening is our phone is, like, the main line is down on that pod desk. When we were part of development services, it made sense, but now that we're a separate department, it needs to be moved up and then put on Kim's phone.
I want to ask you about that ad in the paper the other day. It floored me. Asking for developers to come in on that property uptown.
The Forbes property,
Yeah.
that's a Karen Lemons question, but what can I do
I
for you?
have never seen that before.
Begging
From
someone to
Yes,
come in.
I have never. What happened to the gentleman that was going to develop it?
I think that what happened was they had a rental agreement, and I don't know if you know anything about this, Shay. They had a rental agreement, and the rental agreement never actually was activated, so because of that, they decided to terminate the lease at this point.
That is sad, because he had
Yeah.
a wonderful plan.
Unfortunately, I wasn't able to pull it off, so they requested that the city consent.
I
to
think the city
terminate
didn't
lease.
act fast enough, is what I think now. But it's sad, because that would have been good. Well, first of all, the building should never have been torn down. It's a historic building. And,
I think it was too far gone, was the
no.
problem.
I'll sit and have coffee.
You have any other board comments right now?
During that coffee, we're certainly not going to discuss any matters that will come before this meeting.
It's a history lesson. It's a history lesson.
And that's all that I have for comments, just to give you guys updated, and right now I have no applications for your next meeting, so I'll let you know in the next couple of weeks. Still a couple of weeks before the next meeting, so deadline ends. So I'll let you guys know ahead of time, and if possible, we'll probably go ahead and cancel the meeting, if there's no applications to come forward.
It's for December?
For December, yeah.
Okay.
And then when I get the schedule, you'll see that the meetings have somewhat been shifted around because I can't do 3 board meetings in a week. It's just too much. As much as I love everybody, doing
So you-
P and Z on Mondays and
Gotta have a life.
board on
Well,
Tuesdays
when's
and,
the Christmas party? That's what we all want to know.
you wanted a Christmas party? You should have told me that. You should have told me in May so I could have planned it.
You'll email us that?
Yes, I'll email you all that information. As soon as I know if we're gonna cancel the
Perfect.
meeting, I'll let you know, because obviously I don't want you guys coming in if we don't have any applications to
You
discuss.
can always call me at work or at my house after 1 o'clock. in the
Yeah,
morning.
we'll let you know. We'll let you know. But at this point, we have no applications, and that's all that I have.
All right. Any board comments at all?
Happy Thanksgiving.
Happy
Happy
And Merry
Thanksgiving.
Christmas if I don't see you.
And Merry Christmas.
And remember, more gallbladder attacks this time of year till after the New Year and heart attacks, so eat moderately.
Good advice.
Good advice.
Okay,
Thank you.
board adjourn at 8:03.
So I made you a bag.